I'm Jim Astrachan.
And I'm Donna Thomas.
And we're from Astrachan, Gunst, and Thomas in Baltimore, Maryland. You can find our website at agtlawyers.com. Hi, Donna.
Hi, Jim.
How are you today?
I'm doing well, thank you.
Well, we're here to talk about trademarks again. And we're going to talk about different aspects of trademarks because let's assume for the sake of this conversation that we have a trademark. And let's even go one step further and let's assume that we have gone through the trouble and the expense of having that trademark registered.
Okay.
And we're using it, and we're very happy about our trademark. It's a good trademark. It has a lot of value. It has goodwill associated with it. What we're going to talk about now is a way or ways that you can lose your trademark through a term called abandonment.
Okay.
Have you ever heard of abandonment before?
I've heard of abandonment, yes.
All right. So what is abandonment, Donna, in its broadest sense?
So abandonment is when you cease use of a trademark with the intent not to resume use.
Ooh, the intent not to use it.
Intent not to resume use.
Well, intent is something that can be very difficult to discern. You can't screw off the top of somebody's head and pry inside with a flashlight and figure out what they really intended. So how do you prove intent? Are there any statutory presumptions? What do you do?
There are. So a lot of people think if you just stop using a mark, that results in abandonment. No, you've got to establish intent not to resume use. So under the Lanham Act, which is the Federal Trademark Act, intent not to resume use can be presumed if you discontinue use for 3 consecutive years, which would then shift the burden to the other party to establish that it has an intent to resume use or that it has used within the 3-year period.
So it's a rebuttable presumption, but it's a presumption under the statute, and once those 3 years of non-use have passed, then the burden would shift to you to show that I did have an intention to continue. Is that correct?
That's right.
It's a rebuttable presumption.
That's correct.
All right. And abandonment could result in a total loss of rights.
Right. Abandonment of a trademark relegates the mark to the public domain. So it's up for grabs for anybody else to use at that point.
Now, are there any other ways that you could abandon your trademark?
Well, in addition to discontinuing use with the intent not to resume use, you could abandon a mark through something called naked licensing, where you are allowing a third party to use your mark and you're not exercising appropriate control over the quality of what is offered and sold under the mark.
So let me get this straight. I want to allow somebody in California to manufacture something under my mark, and I license them the use of the mark. And you're saying that if I do not exercise control over the quality associated with the product that bears my mark, then I could be found to have abandoned my mark.
That's correct.
Why is that?
Well, a trademark symbolizes the goodwill and the quality of what's sold under the trademark. So when you go to any McDonald's, you expect the food to be of a certain taste, a certain quality. It's got to be uniform. It's got to be consistent.
Can we say McDonald's in this piece?
Sure, we can say McDonald's in this piece.
Okay,
this is educational.
I just wanted to be sure.
So it is a signifier of uniform quality, of consistent quality. You know, when you buy Nike or Under Armour, you expect every piece of apparel to be held to a certain standard of quality.
And that's you as the consumer.
That's you as the consumer.
And that's what a trademark signifies. So I think what you're saying is that if you license the use of your mark and you don't assure that the quality is consistent with your use, then you have done something by your commission to have lost your rights in the mark.
That's correct.
And that often comes about when you try to enforce your rights against somebody else, and that person finds in a process called discovery that you have exercised your right to license your mark, but you haven't exercised your right to control the quality of the goods.
Right.
And that person will then raise the defense that you no longer have a valid and protectable mark, correct?
Right. Now, it doesn't necessarily mean that you have to have a written license agreement with rights reserved in order to review, obtain specimens, review quality. That's the best practice, is to have a written license agreement which has the rights to obtain samples or to review services and to actually exercise those rights. But there are certainly instances where if you have two parties, licensor and licensee, who are intimately familiar with the business of one another and the products of one another, that's going to be deemed sufficient quality control.
It may be, but that's a factual determination, and then you're going to be at the whim of a jury or a judge in a bench trial.
Right.
So better to have a written agreement.
Always better to have a written agreement.
But let me ask you whether it is dispositive to have a written agreement or that contains quality control clauses, or must you also exercise your rights and obligations?
You also need to exercise your rights. You can't simply have a written agreement and then have years go by where you've never even sampled or
So
reviewed the business.
Form over substance. The agreement's not sufficient. What
Right.
you want to be doing is you want to be requesting samples on a regular basis so you can
Right.
determine whether your licensee's manufactured product is as good as yours, correct? Now, do you want to look, if you were in-house counsel, for example, is it possible that press releases and advertisements might constitute evidence of an intent not to resume the use of the mark?
It's absolutely possible. It depends upon, how firm the language is. So if you send out a press release that says, effective as of X, our company is now called Y, then you have likely abandoned your prior business name, and you have now announced to the world that you're going to be using this new mark.
And that can create a real problem for the company, even if the company was going to continue, or especially if the company was going to continue servicing old products made under the prior name. So this is a very important role for in-house counsel to serve. Review what the marketing department is publishing.
Right, and even if you are going to switch brands, or let's say, for example, you are going to modernize your mark. This happens regularly, right? Over the course of time, a trademark holder wants to make changes to its mark. So those changes could result in an abandonment of a prior version or an abandonment of trademark rights altogether, which you might have taken years or decades creating, right? So as long as the new form and the old form have the same continuing commercial impression, you can tag on and tack on and rely on those prior rights, which could be very important in a priority dispute. But that's something you want to have thought through to understand as you create a new iteration of your mark. It's important to try to preserve those prior rights.
And examples of this sort of, march of iterations might include the Morton Salt logo. That is going through iterations where the little girl with the umbrella, who is sheltering herself from the salt, has changed her clothing to keep with the times, change the style of her umbrella to keep with the times. But commercial impression, as you mentioned a moment ago, that would be something that's also a question of fact for a jury to determine, correct?
It can be. I mean, there's subjective elements to that,
They're very
right?
subjective elements.
Right.
And if you look at, the Supreme Court decision with the hardware case, the court held that attacking commercial impressions is a question of fact for a jury to determine. Right. Okay, I'm Jim Astrachan.
And I'm Donna Thomas.
And we're from Astrachan, Gunst, and Thomas in Baltimore, Maryland. You can find our website at agtlawyers.com.